Emergency orders of protection in Illinois. When abuse erupts within a family, Illinois law lets victims act swiftly. Orders of protection stop abuse by a family or household member. Because danger cannot wait, most cases begin with an emergency order that is heard ex parte. A judge can grant relief without notifying the respondent. Though courts ordinarily require notice, an emergency order can issue without it when exigent circumstances exist, giving those in immediate danger a path to safety without warning the abuser. Courts must balance rapid protection with due process. An emergency petition is a distinct cause of action. A summons must be issued and served, but service may occur after the hearing. The law directs judges to treat these petitions as expedited proceedings and decide them promptly, even if the respondent does not appear. Judges may question petitioners to clarify facts. The standard of proof matches that for a plenary order. The court must issue an order if it finds the petitioner has been abused by a family or household member. Abuse includes physical violence, harassment, intimidation, interference with personal liberty, or willful deprivation. Harassment covers conduct not needed for a reasonable purpose that would cause emotional distress, such as disturbances at work, repeated calls, stalking, or threats. The petitioner needs to show only that abuse is more likely than not. When the respondent isn't present, courts often find this low bar satisfied. A judge may grant an emergency order if harm would likely occur with advance notice, and a verified petition and testimony can demonstrate the need. Once granted, the order and file are sealed. Until the respondent is served, access is limited to the court, petitioner, law enforcement, domestic violence advocates, the party's counsel, and the state's attorney. After service, violating the order is a crime. A respondent can be arrested without a warrant for knowingly breaking its terms. Police notify the respondent that they must stay away from the petitioner. An emergency order is temporary. It lasts between 14 and 21 days. Courts can extend the order while waiting for service, but the emergency status cannot continue beyond 21 days after the initial period. After that, a plenary hearing is held where the respondent can defend themselves. Plenary orders may remain in effect for up to 2 years and can be extended if circumstances persist. The temporary nature of emergency orders means petitioners often return to court until a plenary order issues. Keeping the file confidential prevents respondents from discovering proceedings before being served. Meanwhile, the threat of arrest for violating an order deters further abuse. Because most emergency orders evolve into plenary orders, understanding both stages, filing a verified petition, meeting the low standard of proof, serving the summons, and transitioning to a full hearing, helps protect victims while preserving the respondent's rights. This area of family law can be complex. Consulting a skilled Chicago divorce attorney can clarify the process. The Law Office of Russell D. Knight provides in-depth resources on orders of protection and promises clear communication from the lawyer handling your case. If you need immediate help, contact this law firm at 773-334-6311 or visit 1165 North Clark Street, number 700, Chicago, Illinois, 60610. Their attorneys are available to discuss your options and guide you through securing an emergency order and its subsequent hearing.